Okay, I hope this works this time. I did decide to go with the StreamYard. Okay, let me just double check that I am live and I can hear myself. Sorry about the technical difficulties. I am live and I can hear myself. Yeah. Sorry about the technical difficulties. Okay, awesome. I don't know what it is. It's like everything, all the other stream services or stream platforms that I have just don't want to work. And then here's StreamYard. All right, so we're back. I did give the link to Kathy, so hopefully she will grab that when she sees it. And then for now, I could just start to read a little bit of what of the state's response here. So I can get started for you. So welcome everybody. Oh, Diane, welcome. It's good to see you. Can you hear me now? I checked the sound just a second ago and it sounded pretty good. Yes. So it's like the only thing that wants to work is StreamYard. Thank you for that suggestion, Diane. I was trying to find other things to work, but it's just like it's the gold standard apparently. Great. So my audio is going good. We've got Diane back in the chat. Great. Good to see you. All right. So I will start this over. Thank you. Thank you, Diane. So, none your business. Welcome. Great. That's great that you're here to listen. My sound should be good now, so listening is great. So today we're here to read the state's response to defendant's motion in limine, number 11, regarding exclude IGG evidence. Comes now the state of Idaho by and through the Latell County prosecuting attorney in response to the defendant's motion in limine regarding investigative genetic genealogy, IGG. The defense's motion rests on inaccurate factual assertions and an erroneous legal standard. Nonetheless, the state does not object to and has, in fact, also moved for the exclusion of the IGG information at trial. Facts. June 2023, the state moved for an order protecting the information related to the use of IGG in this case, including the raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as the chain of custody forms, laboratory standard operating procedures, analyst notes. The state argued the IGG information did not fall within Rule 16 of the Idaho Criminal Rules because it was used only as a tip, and the state has no plans to present IGG information for which a protective order is sought as evidence at trial, other than having an investigator testify only that they received a tip pointing law enforcement to the defendant. The state suggested that the court review the IGG information in camera to determine what, if any, IGG information would be disclosed to the defense. Welcome, Moonvale. Good to see you. The court found the state's argument that the IGG investigation is wholly irrelevant since it was not used in obtaining any warrants and will not be at trial. is well supported. But also determined the defense may be entitled to some IGG information. Accordingly, the court granted the state's request for an in-camera review of the IGG information. The state gathered the IGG information from the Idaho State Police, or ORTHM, which is the private lab who contacted the Idaho State Police and the FBI and turned the information over to the court. The information provided to the court included original documents as well as some descriptions of other IGG-related information that was available for further review, and the court chose to do so. After the in-camera review, the court issued an order describing which pages of the IGG information to be disclosed. The state then provided the defense with materials the court ordered disclosed. The court in-camera order and disclosure order made it clear that all IGG discovery was to be filtered through the court. Nevertheless, a few months later, the defense sent supplemental discovery requests to the state regarding additional IGG information. The state objected to all requests. The state explained the basis of this objection was that the state provided the IGG information to the court. The court already ordered what IGG information should be disclosed to the defense, and the state had already disclosed that information. At the hearing on the defense motion to compel the IGG information, the state made the same argument asserted in written objection. The state explained after it had received the in-camera order, it reached out to the private lab and to the FBI and asked everything related to the IGG. The state explained it was not fighting the in-camera order or trying to withhold from the court of any IGG information. The state asserted that after receiving the new IGG request, the state showed the new request to ORTHM, and ORTHM said they had already given everything they had to the state, to the extent that new requests were asking for anything beyond what had already been provided. ORTHM had told the state it did not exist. The court clearly understood the state's argument to be that the requested materials either had been turned over to the court or did not exist, because it concluded the discussion on ORTHM's materials with the question. The court said, so ORTHM has said, you have asked them, and they said they've given you everything we have. The state said, yes. The court denied the defense motion to compel, and as it related to the IGG, the defense later moved to suppress all evidence collected as a result of the IGG on the basis that the IGG process violated the defendant's rights under the Fourth Amendment at the January 23rd, 2025 hearing on the motion to suppress. ISP Lab Director Matthew Gemme. Welcome, Almost Thinking. Good to see you. That's great. Matthew Gemme testified that the ISP had received ORTHM's standard operating procedures in the context of the bidding process and used ISP to secure a private lab to perform work related to IGG. Shortly after the hearing, the defense sent additional discovery requests to the state related to the IGG information, including a request for ORTHM's protocols and procedures as testified by Matthew Gemme. The state put together a response objecting to each of the IGG requests for the same or similar reasons it had objected to previous IGG-related discovery requests. The IGG discovery had already been handled through the process established by the court in-camera order and disclosure. So here's the long footnote. Consistent with the colloquy at the hearing, the court order gave the defense the benefit of the doubt and interpreted the request related to Ortham to be asking for additional materials that were not already known to the court, rather than as an attempt to evade the court's protective order and secure from the state materials the court had already ruled on. The defense's interpretation that the court was saying none of the requested information existed at all is not consistent with the record. For example, one of the requests asked for the names as CVs of the individuals responsible for the work at Ortham. Obviously, the state never represented the court that the individuals who worked at Ortham did not have names or CVs. In fact, the state had already disclosed in-camera information about the chief scientist who did the work at Ortham, including his name and qualifications. Similarly, another Ortham-related discovery request asked for any data file that was uploaded to any commercially available database, and the state expressly told the court, both in writing and at the hearing, that documents existed that were responsive to the request but had already been turned over. Stating in response to request 3 that no such data file exists other than the SNP profiles already provided, emphasis added. So, okay. Well, let me come back and say hello before I go to the next page. Hey, everybody. Okay. In putting together its response, the state learned that Ortham had provided its standard operating procedures to ISP, but ISP had not provided them to Latah County Prosecutor's Office to be disclosed to the court. In response to the court's December 29, 2023 in court order, specifically on February 9, 2025, the state first recognized that the form Ortham filled out during the bidding process asked the bidder to submit written standard operating procedures, and Ortham's response indicated that Ortham uploaded its standard operating procedures as the file SOPs in .zip. The state compared Ortham's response to information provided to the court in response to the in-camera order and found the state did not provide the SOPs.zip file as an attachment to the bid. Upon further review of its records, the state found that ISP had not provided the SOPs.zip to the Latah County Prosecutor's Office. Now, even if that was an accident, that sounds like Brady, or at least prosecutorial misconduct, because you're supposed to hand all that over, even though the state is trying to say they don't have to. Just 2 days after learning this information, the state provided to the defense and filed with the court its response to the defense recovery request. The state explained in its response that the bidding documents included the court's in-camera review, revealed that the existence of Ortham's standard operating procedures, but the state had inadvertently failed to disclose the standard operating procedures themselves. The state also explained that standard operating procedures were covered by the court's protective order because the court had not required the disclosure of any of the bidding documentation, that the motion of understanding included the document that revealed the existence of the standard operating procedures on the basis that the remaining contract documents are not relevant to any issue in the case. Boy, do they have that wrong. Not according to the scientific community. All of that's supposed to be turned over. 2 weeks later, the defense filed a motion in limine asking the court to exclude IgG evidence from the trial on the basis that the state allegedly violated Brady. And I would agree with that, because it's my understanding that when the defense specifically requests for the standard operating procedures, then it is discoverable. And the defense has been asking for that since 2023, probably before then. I believe it was in the third motion the third request for discovery, but I might not be sure about that. Let's see here. So, argument. The defense motion is based on the mischaracterization of the record and inopposite case law. The state did not act in bad faith. The state never made the concession the defense now claims, and the defense's reliance on Youngblood is legally erroneous. The defense has failed both legally and factually to the substantive a Brady violation. Okay, so Youngblood must be a case that they referenced. We can look that up real quick before we move on to the Youngblood case law. Well, the state didn't provide any dates or anything, but this came up under the Innocence Project. Larry Youngblood was wrongly convicted in 1985 of child SA kidnapping and spent a total of 9 years in prison before he was fully exonerated of the crimes. In October 1983, a 10-year-old boy was abducted from a carnival in Pima County, Arizona, and was SA'd by an unknown man. The victim was taken to the hospital where the staff collected semen samples as well as the clothing he was wearing at the time of this assault. In the investigation and trial, based on the victim's description of the assailant, a middle-aged black man with one disfigured eye, Larry Youngblood was a black and had a bad left eye, became a suspect. He was put in a photo lineup, and the victim identified him as the perpetrator. Youngblood maintained his innocence at trial, but the jury convicted him based largely on the eyewitness identification of the victim. He was sentenced to 10 years and 6 months in prison. No serological tests were conducted before trial as the police improperly stored the evidence that had degraded there. This is exactly why the defense is referencing the Youngblood case. The serological tests would be the SNP and the standard operating procedures, because that goes in and it pairs in tandem with the actual. It's part of the DNA interpretation. So the post-conviction, this should get into the actual case law here. So Larry Youngblood appealed his conviction, claiming that the destruction of potentially exculpatory evidence violated his due process rights. The Arizona Court of Appeals set aside his conviction. He was released from prison 3 years into his sentence, but in 1988, the Supreme Court reversed the lower court's ruling, and his conviction was reinstated. Youngblood remained free as the case made its way through the Arizona appellate court system a second time, but returned to prison in 1993. When the Arizona Supreme Court reinstated his conviction in 1998, Youngblood was released on parole, but was sent back to prison in 1999 for failing to register his new address as required by this Arizona sex offender laws in 2000 upon request from his attorney, Scott McNamara, and Carol Weddles with the Innocent Project, acting as a consultant to the police department, tested the degraded evidence using new sophisticated DNA technology. The results exonerated Youngblood, and he was released from prison in 2000. The district attorney's office formally dismissed the charges against Youngblood later that year. Shortly thereafter, the DNA profile from the evidence was entered into a national convicted offender database. In early 2001, officials got a hit matching a profile of Walter Cruz, who is blind in one eye and is currently serving time in Texas on unrelated charges. In August 2002, Cruz was convicted of the crime and sentenced to 24 years in prison. Sadly, Youngblood died in 2007 without receiving any compensation for his wrongful conviction. Oh my gosh. So that is why the defense is referencing this case, and I would say for good reason. We need to be able to check the accuracy of the results, or this same situation could possibly happen to Brian, and that is exactly why it would violate his due process rights. That is just terrible. So then when we come back here to the state's response, this is what they said. The state did not act in bad faith. The state never made the concession that the defense now claims, and the defense's reliance on Youngblood is legally erroneous. Yes, that is ridiculous. I can't believe the state is saying that. Even if they accidentally did not, if it was accidental, they did not provide the SOP, standard operating procedures, it's still the same thing. And so she's still asking for the information that they had. They need to be able to look at the work or either try to reproduce it to avoid what happened to Youngblood. So let's continue on. The defense, I have put the link to the article that I was just reading from the Innocence Project in the chat. I will put that below if you're interested, for anybody who's live or anybody on Replay Crew. Hi, Replay Crew. So that'll be in the description for you. So moving on. The defense has failed both legally and factually to substrate a Brady violation. A, the defense's motion is based on the wrong legal standard. The defense's motion relies on the wrong legal standard by confusing Brady and Youngblood. The Brady standard asks if the state withheld exculpatory evidence that had a reasonable probability of changing the outcome of the proceedings and applies irrespective of good faith or bad faith of the prosecution. Brady applies when the state possesses but fails to disclose allegedly exculpatory information or exculpatory evidence. It says, see State v. Campbell. However, a separate issue arises when the allegedly exculpatory evidence was not withheld by the state, but rather lost or destroyed by the state. Well, the state, it's like, state, if you're not turning over this information, which we are entitled to, either you don't have it or you destroyed it, or turn it over. And so it's like, if you're not turning it over, where is it? So yeah, it would be lost or destroyed if you can't turn it over. So I don't understand why they're saying that. In that circumstance, the Youngblood standard asks whether the state acted in bad faith. Idaho's appellate courts have been clear about this distinction for decades. See State v. Sarbacker. While we have consistently held that Brady applies when the state fails to disclose known exculpatory evidence, we have applied Youngblood in cases where the state has failed to preserve material evidence of unknown exculpatory value. State v. Ward from Idaho, explaining the district court failed to distinguish between the state's duty to disclose evidence and the state's duty to preserve evidence. and that Youngblood applies only to the state failed to preserve potentially exculpatory evidence. Yeah, but if they don't turn over the work they did, yeah, it's potentially exculpatory because there's an unknown there. And to be able to determine whether it's exculpatory or not, you got to look at it. And since the defendant is presumed innocent, then anything that's missing is potentially exculpatory, I would think. Determining which legal standard applies as it sounds, for example, in a case where the state possessed but failed to disclose an allegedly exculpatory social media post, the Idaho Supreme Court held Brady was the correct standard. But in a different case, when the state destroyed or deleted an allegedly exculpatory social media post, the court held that Youngblood applied. Here, Brady applies because the defense alleges that the state failed to disclose Ortham's standard operating procedures. Youngblood does not apply because the defense has not alleged the state lost or destroyed Ortham's standard operating procedures. Because Brady applies rather than Youngblood, whether the state acted in good faith or bad faith is irrelevant. What? Why? Why would they ever say that? Wow, they just look so dishonest right now. It's like the proper response is here. Here are the standard operating procedures. Oh my gosh. Okay, so thus, the defense's motion, which rests entirely on its faulty accusations of bad faith, fails from the get-go. Though legally correct, it is unfortunate that for the state that Youngblood does not apply because there's no reasonable reading of the record that supports the finding of bad faith. Bad faith is a high bar requiring more than mere negligence. Rather, bad faith refers to a calculated effort to circumvent the disclosure requirements established by Brady v. Maryland and its progeny, State v. Sarbacker. There was no calculated effort to circumvent Brady. The state disclosed to the court the records it had receiving regarding the bidding process. Then, just 2 days after learning that the standard operating procedures themselves were inadvertently left out of the material provided in camera review, the state notified the defense and the court still 6 months before trial. The state acted in good faith, and there is no reasonable basis to conclude otherwise. Oh, that doesn't look good. B, the defense has not and cannot provide a Brady violation or cannot prove a Brady violation. The defense has not and cannot prove a Brady violation related to Ortham's standard operating procedures. There are 3 components of a true Brady violation. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must be suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. The defense has not proven any of the components. Oh my gosh, my heart just sank. Because as far as we know, I don't know if Hitler understands that these standard operating procedures are very much a part of the DNA interpretation that goes hand in hand with actually looking at the genetic material and the outputs from the software. So yes, that would be exculpatory because if you're missing some of the DNA interpretation, then it's incorrect because you're missing parts, right? I don't know. This is scary. Oh gosh. Okay, so first, the defense has not shown that Ortham's standard operating procedures are exculpatory or impeaching. Well, if they haven't been able to see them, how are they supposed to know? and it is exculpatory if they can't turn it over. This is insane. Much of the defense's argument is based on a misreading of the transcript of the May 30th, 2024. To say the state conceded the IgG information is irrelevant to the case. Of course, relevance is not the proper standard. Explaining Brady only applies where the evidence is favorable to the defense. In any event, the defense is wrong about the state's concession. The defense omitted from its motion the beginning of the state's argument at the hearing, which demonstrates that the state maintained its position that none of the IgG information is relevant, and that the state references to the court's order were referring to the in-camera order requiring that the state to turn in IgG information over to the court, not the disclosure order requiring the state to turn some of the IgG over to the defense. Can you believe it? Is this like Bico Barlow like catching them red-handed and like this is their response? So it says here, the state says, thanks, Judge. So I just want to start with maybe a bigger picture for a second. You know, we started with arguments about whether the IgG stuff is relevant at all. We, of course, made our argument that it is not relevant at all. It shouldn't even have to be produced. The court made a ruling on that. We still don't agree with it, but we understand. How can they say that? Okay. The court says, I understand. The state says, the court makes the decisions, and so we complied with that order. In light of that portion, the state's argument, it is clear that the next portion of the state's argument was nothing more than the state acknowledging that, to the extent the requested materials exist. Those materials fell within the scope of the court's in-camera order, and pursuant to that order, the state had to turn over those materials to the court. The state says, we have talked to Ortha. We have spoken to Ortha. Since we have gotten this Exhibit N and provided them these requests, and we are not in a position. For example, requests 1 through 6, we are not fighting those. I am not saying we are not going to turn those over. In my view, they fall pretty clearly under the court's order. The issue is we go to Ortham and show them these. And Ortham says, we have given you everything. You have everything. Everything we have was given to the court and then provided to the defense. So there's nothing on this list that we are holding back because we have some justification for doing so. Ortham is just telling us we don't have it. Oh, Momo's thinking says, I think AT could have handled this better, but I don't know, probably wrong. Oh, I agree with you. Yeah. The defense's misreading of the transcript pales in comparison to its misreading of state's motion for a protective order. The defense tries to claim the state conceded in its motion that all information related to Ortham's work was relevant because the state agreed to provide the lab report pursuant to Rule 16b-5. Nothing could be further than the truth. The state dedicated an entire section of the motion to explaining why Rule 16b-5 required only the disclosure of the scientific report and nothing else. The state also affirmatively argued to the rest of the IgG information should be protected because it fell outside of Rule 16, including any raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms, laboratory standard operating procedures, and analyst notes, etc. Second, the defense has not shown that the state suppressed Ortham's standard operating procedures because those documents have been withheld from disclosure to the defendant pursuant to a protective order. Idaho's appellate courts have looked with favor on the use of an in-camera review process for a trial court to determine whether evidence is exculpatory or impeaching. The court ordered such a process in this case. While Ortham's standard operating procedures were inadvertently left out of the material presented in camera, the materials were provided where sufficient to obtain a ruling from the court that information Ortham provided to IASP as a part of the bidding process was not relevant to the case. Yes, well, maybe not that information. Well, maybe it actually is because that's part of the standard operating procedures. I don't know if this is like flat out lying to the court, because I guess it depends what the court decides it is, but this is the direct opposite of what the scientific process is for DNA interpretation. This is cringeworthy what they're saying here. I guess he's so sick. As the state explained in its response to the defense's recovery request, Matthew Gammy testified about Ortham's protocols and procedures in the context of the bidding process. The documents related to the bidding were included and referenced in the materials provided to the court to the review in camera. The court required the state to discover only the motion of understanding from the bidding process or the bidding documents. The state need only discover pages 99 through 103, the memorandum of understanding. The remaining contract documents are not relevant to any issue in the case. Well, it actually might be relevant to the case because isn't it the funding that the state gets or the exchange of funds that happen between Ortham and the ISP lab that is discoverable to the defendant, I thought. And mostly because that's probably taxpayer money. I don't know that. Uh-oh. I clicked on something. Wait. Okay. Jackie, welcome. IDAHO4 says, defense is not at its best. Yeah. Well, I also think that Ann Taylor, I believe she's playing the long game because I think she knows how the state is playing this, and they're not actually playing this straightforward or fair. So as long as she gets her record, and her record is good, because she's getting all of this on the record, is that the state is admitting here they inadvertently did not include the standard operating procedures. And so when it comes to appeal, she's going to have all this information to work with. So even though this might be, it's kind of scary to me, and I think I've heard other people say that, hopefully if the appeal is actually needed and the jury can actually see what's going on here, or if they can't, hopefully the appellate court will have a completely different vibe about it, and that it will actually look at what is going on here. And this is withholding part of the DNA interpretation right here. And I do believe that Becca Barlow is going to get that on file or on the court record, that article the human factors and the systems approach, that really long 430-page study and report that we actually read together before Becca Barlow actually referenced it in her motion in Limine for the use of the terms touch and contact DNA. And so she will be able to get that. And if that is actually on the record for when or if the appellate court looks at it, I do believe they're standing there to reverse any decision that was made in the lower court. But we'll have to see. But that is just my feeling about it. All right, moving on, we're going to go back to reading page 10 here. It says, the court did not require the state to produce any of the other bidding documentation, including Ortham's bid submission that discussed Ortham's accreditation status, other customers, past cases, the name and qualifications of the primary genealogist, the name and qualifications of the chief scientist, and the standard operating procedures or analytical methods that were to be used. Though the standard operating procedures were inadvertently excluded from the materials reviewed in camera, the bidding document referenced the standard operating procedures were included, and the court did not require disclosure of that document or the SOPs, standard operating procedures. If the defense disagreed with the state's position, it could have filed a motion to have the court rule on the issue. Instead, the defense chose to skip that step and jump straight to alleging the state violated Brady. Are they serious? It is Brady. If you can't turn over part of the DNA interpretation. The defense's only, okay, I'm going to read on. The defense's only explanation for jumping ahead to the exclusion of the IgG information instead of first asking the court to order the disclosure of the standard operating procedures is a conclusionary statement that the defendant would be significantly handicapped by production of the materials sought at this late date. Because with the earlier disclosure, he would have been able to utilize the materials for motion work and consultation with experts. But when the Brady issue is one of the delayed disclosures, the question is whether earlier disclosure would have created a reasonable doubt of guilt. But let me read that again. But when the Brady issue is one of the delayed disclosure, the question is whether either disclosure would have created a reasonable doubt of guilt. I feel like the lack of disclosure also creates it. So it'll create it, even if it's disclosed or not disclosed. Reading on. In thumb, the Idaho Supreme Court found disclosure of a fingerprint report just 1 week before trial did not violate Brady because the defense had enough time to review the report and its conclusions if she sought to do so. And the state then agreed not to use the report in its case in chief. Here, the defense was informed that the standard operating procedure 6 months before trial. The defense has not even attempted to articulate with any specificity how the standard operating procedures could make any difference in the jury's determination of guilt. And the state is not seeking to use the standard operating procedures. Well, they're not. Well, then that's a problem. That is a huge problem if the state did not use them. Is that what the state is saying? They didn't use them and they're not going to use them. Or any of the IgG information at trial. That is a huge problem. Oh my gosh. Okay. Third, the defense has not shown prejudice, and the law and logic dictate that the defense cannot show prejudice with respect to Ortham's operating procedures Prejudice and materiality are used interchangeably in the context of Brady. Well, I don't know how they can state that because, like Stephen Mercer was saying at that, was it June 2023 motion to compel hearing for the IgG, the DNA hearing, he said they need the information so they can check for the accuracy. I feel like that if the state doesn't provide that, that is definitely Brady. And young blood too. It's going to remain unknown whether the work was done accurately and if they actually have functional standard operating procedures. Because if there aren't functional standard operating procedures, the whole process of DNA interpretation could be skewed. And it looks like that could be happening here. Otherwise, why aren't they just why isn't the state cooperating? You know, like this is so bad. Reading on, when assessing materiality, the question is whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine evidence in the outcome. Well, yeah, that's exactly what could happen. Reading on, such evidence is material if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Nothing about IgG in this case, including Ortham standard operating procedures, comes anywhere close to being material for purposes of Brady. I don't know how they would know that. Hi, Preston B. Welcome. What IDAHO4 asked, what article and page is this? Okay, so this is page 12 of the state's response to defendant's motion in Limine number 11 regarding exclude IgG evidence. All right, let me come back for chat. And then after that, we'll move on from page 12. Oh, Jackie says, I have my earbuds in getting things done around the house. Woo woo, good job, Jackie. Multitasking. That is a very special skill not everybody has. So Memo's Thinking says, I feel like we're going in circles with the state. That is a great way to put it. I agree with that. Yes. IDAHO4 says, IDAHO4 is Diane, but I love your channel name, Diane. If anybody hasn't subscribed to IDAHO4, definitely do that. She's a great creator. IDAHO4 says, this stuff is hard to get. Yes. Momo's Thinking says, is the only DNA evidence tied to BK's the sheet? Yes. Yes, so the only evidence is trace transfer DNA. It's only a few skin cells that are smaller than the point on a pen. And what that means it's degraded DNA. So there's going to have to be a little bit more care when interpreting this DNA. And to do that, you have to be able to maintain your accreditation for your lab, maintain your standard operating procedures to make sure that the methods that the lab uses are accurate and functional. And so you're already looking at damaged DNA, which was found on brass, which made it accelerate at a rate of damage more so than any other surface except for copper. Copper's DNA accelerates on that at a faster rate. So yeah, and especially when you're not looking at the blood, sweat, semen, or saliva, these standards and these practices and these methods are crucial to understanding what it is the lab is looking at. And, the even bigger picture is an innocent person could go to prison because of misinterpretation, or that the methods used skewed the data. Okay. To Die For says, enjoy listening and cleaning, Jackie. Yes. To Die For, the DNA was found on brass, and it was at least enclosed, if it was on there at all, because I thought that, are we still unsure if it was actually swabbed, or did it say that it was? Because if the snap was closed, it would be completely encased in brass for, I guess, at least 12 hours, because there was an 8-hour delay, and then there was 4-hour delay for when Payne supposedly got to the scene and he said the texts were there. So at least 12 hours. Or it could have been enclosed, in the cup, because like the piece that I believe it was found in was the cup part. What is that, the female part? So it would have been enclosed on at least 3 sides as well. Yvonne Poole, welcome. Very good to see you. Yvonne Poole says, I think that the defense not able to do their own independent test of the transferred DNA is what hurts them the most. I agree. Yvonne Poole goes on to say they used it all, and whether it might have been left was ruined by the fingerprint. Yeah. Momo's Thinking says, I don't think all jurors will be guilty. In my honest opinion, not. Next to unknown. Yeah, good point. Momo's Thinking says it depends who you ask. That's funny. Okay. Excuse me. All right. We were up here on page 12, right? Right. We left off with prejudice and materiality are used interchangeably in the context of Brady. When assessing materiality, the question is whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine the confidence in the outcome. All right, let's think about it here. If in fact the standard operating procedures created that skewed the data for whatever reason, that the interpretation of that ortham was not yielding results that were accurate, and if the actual genetic material wasn't developed properly or overdeveloped, because we know that the file was over twice the size by the time somewhere between the passing of ortham and when the FBI received it. So any step along the way in that process could significantly change the outcome of this case. Because without this DNA, there really isn't a case. So for them to say that here is just a little inaccurate. Like standard operating procedures recommended by the scientific community is first, test the blood evidence. That is the most, and so whose standard operating procedures were broken when they went directly for the minute amount of trace transfer DNA? And I do think it is discoverable that the defendant be able to recreate or look at the process, the entire process. And here it is, the state is still withholding it. This whole paper is about how the state is withholding it, and they're telling They're going to withhold it. So when assessing materiality, the question is whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the outcome. Such evidence is material if there is a reasonable probability that, had the evidence been disclosed to the evidence, the result of the proceeding would have been different. Nothing about IgG in this case, including Ortham's standard operating procedures, comes anywhere close to being material for purposes of rating. I don't know how they could say that. That was the whole tip. Well, actually, it was more than a tip. Because they developed a profile. Developing a profile shouldn't be a tip, but I guess it's a tip because of the genetic witnesses, which are in the database. So there's genetic witnesses in a database, then you have database hits. I hope that the Supreme Court looks at genetic witnesses from these IgG DNA databases and cold hits on DNA databases, because how can a defendant defend themselves on a silent genetic witness? And I do believe when the defendant cannot defend themselves against that, that is a violation of due process, because the defendant has the right to confront their accusers. So maybe not directly the people on the tree, but the accuser, would that be the actual database itself? Because the database is returning as a result. And that result is identity only. And so we were getting into this when we were reading that large report, the human factors and the systems approach, that big report that Becca Barlow referenced. It says in there that lab analysts are limited to identity. Anything that has to do with the mechanism of DNA transfer, which is direct or indirect transfer, is outside the scope. Lab experts, lab analysts are not trained or educated to interpret or even testify to the means or the mechanisms of DNA transfer. So if they are not educated or trained in that, they cannot answer the question of the activity level, which is the how and the when in regard to the transfer DNA. So identity in the case of trace transfer DNA is only a part of what goes into building a case. You can have identity, but for the trace transfer DNA, you need context around it, and that context would be the how and the when. There is no way a lab analyst can testify to when the DNA arrived on a movable object. And there's no way in these standard operating procedures that it says that that's what they do. These standard operating procedures, they state that their main focus is identity. It is not the means of the how and the when. So when you have all of that together, how can the defendant defend themselves against the how and the when and experts that are inadequate to actually testify in trial? Yeah, your DNA got there and we said it got there, and we have no basis for that. Okay, so the defendant, how can they defend themselves on that? And so, yes, it's imperative that we get these standard operating procedures, that we get that on the court record, because that will show that the state cannot prove the how and the when. And then that'll also prove that, okay, you have identity, but that doesn't go beyond an identification. That doesn't place a defendant at the scene. All right. Let me see if you guys have anything to say over here in the chat. Momo's Thinking says, if it was closed, that makes even less sense because who closed it? Right. And did they swab for fingerprints? Oh, right. Riley Nolan didn't remember if whoever actually did the testing swabbed it. And so if it wasn't swabbed, that's a good question. Was the snap closed, or was it open? Because if it was snap closed and they didn't test for fingerprints, how can you even prove that anybody held that, let alone when they were holding it? This case is going to be a landmark case because of these questions here and the clarification from the scientific community about the how and the when, the activity level. And it also clarifies that lab analysts are limited to identity, and they should not be testifying to direct or indirect transfer. So Yvonne Poole says, that's a good question. Was it snapped or unwrapped when the sheath was found? Yeah, that would make a difference. Yvonne Poole says, what unaliver would unsnap their sheath and take the time to resnap it if without putting their knife back in it? Good question. Momo's Thinking says, none that I know. Yvonne says, whoever left their skin under the button snap would have to have left them before unsnapping at the scene if they were wearing gloves. BK had no other DNA at the scene. That means the DNA was on the brass even longer than 12 hours. I would agree with you. Yeah. IDAHO4 says, sure, Yvonne, if used, there would be actual DNA. Momo's Thinking says, if it's his, it should be in more places. It's difficult to only get trace DNA in that one area alone. I would agree with you. That big report also talked about case-relevant facts. And I would argue this little bit of minute DNA is not necessarily case-relevant. The blood DNA, however, at the scene is case-relevant, not only for me personally, but for the scientific community as well. Yvonne Poole says, if there were no fingerprints on the button part, the skin cells had to have been put there before they touched the sheath after wipe the top button snap. I don't know about that. IDAHO4 says you can't, but a jury will see it that way. It's up to the defense to educate them on the DNA. Great point. Yes, it is. And they have the leading expert in DNA on their side. So I'm sure she'll be able to do it, especially with our help, right? She has a whole research team here. Everybody in chat and everybody on replay, we're all researching this DNA together. And we're putting together a body of work. You know, and that's significant. So Pico Barlow has us too. Brian has us to look into this DNA stuff and to help read through it to, you know, maybe they can pull out ways from us, you know, and how we understand the DNA to help put it. But I'm sure Pico Barlow, she already has a lot of ways that she can make it understandable. She already made it. She wrote that beautiful motion. I can't stop talking about it. I was like blushing when I was reading it. So yeah, she was made for this case. All right, so reading on. It is undisputed that IgG is simply a means to generate potential leads as to who the DNA It is undisputed that IgG is simply a means to generate potential leads as to who DNA found at a crime scene may belong to. If one of those leads proves fruitful, law enforcement can conduct a confirmatory test as to whether the DNA belongs to the suspect using an STR comparison. The strength of that evidence against the defendant in terms of DNA evidence depends upon confirmatory result from the STR DNA analysis between the defendant's DNA and the DNA recovered from the crime scene. The evidence that is material to the defendant's guilt or innocence is testing that followed the IgG. Wait a second here. The evidence that is material to the defendant's guilt or innocence is the testing that followed the IgG investigation, which directly compared a fresh swab of the defendant's DNA with the DNA profile collected from the victim's nightgown. Oh, they're referencing this case above here. There is no victim's nightgown involved in this case. They're referencing in the matter of Michael Green, the ruling. All right, so it was Michael Green's case. Here we go. They're going to talk about the likelihood ratio. I have a video to show you guys that I made earlier today that really goes into detail about this likelihood ratio. So here, the IgG information is less material, if that is possible. Whoa, is this sarcasm right here? If that's possible, then it would otherwise have been because the defense has not disclosed any experts or evidence to challenge the confirmatory STR comparison. Oh my God, did the state just say that? That's the whole reason for all of the IgG information, including the standard operation procedures, because the SMP is used to confirm the accuracy of the STR. And that is on record. That is said, like word for word, from Stephen Mercer from the motion to compel hearing for the IgG information. I can't believe they just said that the defense has not disclosed any expert or evidence to challenge the confirmatory STR comparison. They had a whole hearing on it. They challenged it. I don't know what they're talking about here. Oh my gosh. Okay, to me, this is blatantly lying to the court. But again, it's like, how is the court going to take that as a blatant lie when there was a whole hearing on this? And the SNP is used to confirm the STR. Are they serious? Oh, this makes me so sick that they're writing it like this. All right, moving on. We're reading. The defense has disclosed an expert regarding DNA evidence interpretation and the likelihood ratio to challenge one of the state's conclusions concerning DNA. But the defense has not disclosed any experts to challenge the confirmatory STR comparison showing okay, so the defense has disclosed an expert regarding the interpretation of the likelihood ratio to challenge one of the state's conclusions concerning DNA, but the state further goes on to say, but the defense has not disclosed any experts to challenge the confirmatory STR comparison showing the DNA on the knife sheath matched the defendant's. Oh my gosh, yes, they have. That's the whole reason for all of this. And they've done it in the beginning of the case. It was just one of the first things that they challenged. Wow, I can't believe that they're doing that. On the contrary, the defense has disclosed that its forensic biology and DNA expert will testify that there is a good support that Mr. Koberger's DNA was found on item 1.1 and a swab from the knife sheath. Wait a minute. Is this the defense saying it's not Brian's DNA? So they're contesting that it's even his? Wait, let's read that again, because some of these things can just... They can fly over me too, but this is what I'm picking up here. It says, on the contrary, the defense has disclosed that its forensic biology and DNA expert will testify that there is good support that Mr. Koberger's DNA was found. Oh, I'm sorry, I misread it. So they are agreeing that it is his DNA. The expert will testify that there is good support that Mr. Koberger's DNA was found on the item. Wow. So this is the first time I think we've known that they have agreed that it's his. Let me know if I'm reading that right, guys, because okay. So reading on. Instead of challenging the conclusion of the DNA on the knife sheath belonged to the defendant, the defense's expert disclosures reveal that the defense plans to argue the DNA on the knife sheath does not prove defendant was ever at the crime scene, and the knife sheath itself could have been planted by the real perpetrator. Whoa, this is really manipulative right here. Could have been planted by the real perpetrator? No. Could have been just left there by the actual person who did it. Right? And it's also, I know I've said this a million times, but the scientific community agrees that the type of DNA that was actually found to potentially have matched Brian Koberger does not place Brian at the scene. And so, yeah, the alternative would be the actual perpetrator left it, if that's the state's case, that the sheath is related to the crime, then whoever actually committed the crime is the one who left it, not planned. This is really manipulative right there. Wow. Let me come back and see what you guys are saying, because this is getting heated over here. Let's see. Diane says, you can't, but a jury will see it that way. It's up to the defense to educate them. Oh, yes, I read that one. Momo's thinking says, I think defense is watching YouTube. It's smart. I would if I was working on a defense team. I would have my own media team. I don't know. Can you get interns on it? I don't know how. I just have a team that spends a few hours a day looking at this stuff. To IDAHO4 says, I doubt they have time. That's very true, though. They may not have time. Momo's thinking says, since Rittenhouse, I think they do. Yvonne Poole says, they are going to say that he wiped the sheath but missed the part under the button snap. Ooh. That is a good point, Yvonne. I think you're right about that. Yvonne goes on to say, he would have done that before leaving home, so that DNA would have been on the brass a very long time. Momo's thinking says, cleaning chemicals would show. I would agree there, yeah. Momo's thinking says, dyed leather stitching would catch DNA too. Yeah. Why didn't the actual leather of the sheath catch other trace amounts of whoever did its DNA? Because the trace transfer DNA sticks to fabric a lot better. It actually likes to stick to that, whereas the brass repels it. Very likely, Momo's thinking says, very likely could have been from cross stitch 2, right? Sloppy LE collection, absolutely. Yvonne says, Momo's thinking. He was excluded from any blood on the back of the sheath. That's very true. All right. Where were we? Reading on. The parties' theories demonstrate why the IGG work in this case cannot possibly be material under Brady. Finding allegedly exculpatory evidence is not material under Brady because it was not part of the state's theory of the case. The IGG was conducted as a preliminary assessment of the potential owners of the DNA found on the knife sheath. What? IgG was conducted as a primary assessment of the potential owners of the DNA found on the knife sheath. Okay, so DNA can be found on any item at any time. That doesn't mean the person who owns it, their DNA is actually on it. Where are these people from? Oh my gosh. It's like, okay, your DNA is only on things that you own. What kind of thinking is that? That is completely illogical right there. So they tested it for the owner. We don't even know if that was the actual weapon. We don't even know if the perpetrator may have found that already at the house. We don't even know if the perpetrator stole it, or if it just has DNA on it because that's how it lives in everyday life. We all live in DNA. We all live in trace DNA all the time. All right, so this is just that thinking is so narrow that it's illogical. So this is very logical. Right here, the IgG was conducted as a preliminary assessment of the potential owners of the DNA found on the knife sheath. Oh man, I hope Becca Barlow tears that apart. I would definitely dig into there, and explain even further how DNA on an object does not equal ownership. And identify the defendant as a potential owner. Even if they did identify Brian, there's no way to tell if he was the owner because of the nature of the trace transfer DNA. But it was the scientific process of the STR comparison that confirmed defendant's DNA matched the DNA found on the sheath. Now, the state has no plans to use the preliminary assessment of the IgG at trial. And the defense has no plans to challenge the confirmatory STR comparison. Thus, the preliminary assessment of the IgG could have no effect on the result of the trial. I think the state is going to say that the sheath belongs to Brian, that Brian owns it. So is that another outright lie? It's because it says now the state has no plans to use the preliminary assessment, but you just said the preliminary assessment was to see who owned the sheath. So you are going to use that. You are going to use that, that you believe Brian owned the sheath. Oh my gosh, how many outright lies are going into this? Like, we know the state's case is that it's completely not founded in science. That's already been determined by Baker Barlow. And they're trying to use Riley Nolan to talk about direct and indirect transfer when she's not trained or educated to make such a testimony. And that's their case, that it was direct transfer from the sheath, from Brian to the sheath, and Brian was at the scene. And that is just not scientific because of the nature of the trace transfer DNA. And so now they tested to see who owned it. Oh man, Becca, you can tear that one open. And the defense has no plans to challenge the confirmatory STR comparison. Thus, the preliminary assessment of the IgG could have no effect on the result of the trial. Yeah, it could. If the sheath was owned by somebody else, and if the DNA interpretation for one, part of it's missing or it was done incorrectly. All right, moving on, reading again. At the bottom of page 13 here, the defense erroneously asserts prejudice on the basis that it will not be able to use the standard operating procedures to cross-examine the state expert witness David Middleman, the CEO of IDAHO4. But the state disclosed Dr. Middleton's, he is a doctor. What kind of, is he a scientist? I'm so confused on that. Does anybody know? But the state has disclosed Dr. Middleman only as a rebuttal witness to respond to the two IgG experts the defense initially disclosed. Now that the defense has decided not to call their IgG expert, the state has no need to call Mr. Middleman. That was strategic. I'm very interested to find out if we get to find out further about the strategic move that the defense made here. I don't know if they cut off the snake's head or what. I'm not sure. Okay, moving on. More importantly, however, demonstrating prejudice under Brady requires far more than a showing that the standard operating procedures could be used for cross-examination. Defining the elements of Brady to require the defendant to show prejudice separate from showing the evidence is exculpatory or impeaching. The defense would have to prove that the cross-examination using the standard operating procedures would have a reasonable probability of challenging the outcome of the case. The defendant has not and cannot do so, even if Ortham failed to follow every standard operating procedure. That does not change the fact that the IgG merely pointed law enforcement toward the defendant as the potential owner of the DNA on the knife sheath, or the unchallenged confirmatory STR comparison showed the DNA on the knife sheath matched the defendant. Let me just double check something up here. All right, where did we leave off? The defense would have to prove that the cross-examination using the standard operating procedures would have a reasonable probability of challenging the outcome of the case. The defense has not and cannot do so, even if Ortham failed to follow every standard operating procedure. That does not change the facts that the IgG merely pointed law enforcement toward the defendant as a potential owner of the of the DNA on the sheath, or that the unchallenged confirmatory STR comparison showed the DNA on the knife sheath matched the defendant. The defense also whispers in a footnote that the defendant may have been prejudiced because of the standard operating procedures could have bolstered the defendant's argument that the IgG work violated his Fourth Amendment rights on the basis that it revealed private medical information. Such speculation is insufficient to prove prejudice under Brady. Materiality for the purposes of Brady analysis must test on something more than wild speculation. The defense's speculation also runs contrary to all related evidence presented at the hearing. For example, Riley Nolan, a forensic laboratory manager with ISP, testified that the medical information fell outside Ortham's scope of work. In this case, that the information Ortham provided back to ISP did not contain medical information. Similarly, the defense's own expert who previously oversaw a lab like Ortham and played a role like Ortham in law enforcement investigations testified such labs developed state profiles related to genealogy and ancestry rather than medical information, and developing SNPs related to medical information in the context of IgG wouldn't be relevant nor probative nor appropriate. Now, the issue with that is, I believe it is coming. It's not going to be this year, it might not be in 5 years or 10 years, but I do believe eventually it will be determined that these labs have been inadvertently looking at medical information. I think that will come. And because of that, everything right here that he's saying will, this will no longer be able to be used in law enforcement investigations. And so the standard operating procedures now are very important, because the standard operating procedures, they were used as empirical evidence in that report, that 439-page report for the human factors and systems approach. There were several examples in there. One of them was the silo effect. I believe it was like the Queensland lab in Australia, where everybody, the way that lab was run was skewing the results. And they had that information because they had a foundation of information of the standard operating procedures. Now, the standing operation procedures are important now because in the future, those will be the foundation of probably a future study that does show this is the way that they were doing it back then. And the way they were doing back then absolutely did see medical information. And so we have those standard operating procedures of how they did it, so we know that that did happen. And so now we're going to update our standard operating procedures, and so that doesn't happen anymore. Maybe there will be new techniques. And so what he is talking about here, I do not think will always be the case, which also means in the future, if the laws do change, I do think that's coming, that could change this case, because Bill Thompson has put it all out here. He's given us a lot of information to go on. So looking back on this, whether it's, upgrades in healthcare, upgrades in the actual science part of running a lab, but also in the laws that could overturn whatever is going to happen in this case. Wow. I am just like picturing years down the line, looking back at cases like this, and Bill Thompson just gave up a lot of information here, whether he meant to or not. Now, I know that probably law enforcement and attorneys would completely disagree with me, but I'm in a different sphere. I'm in healthcare. And I work in systems all day. I've studied healthcare systems in college. The systems are my thing. And so that's why I love that article. It's all about the systems approach and DNA interpretation. Like that is my cross section. That is my niche. Like that is everything. I'm so passionate about it that I do see these systems changing. And because of that, I can see different things because of what I'm surrounded with all day and what I'm researching all the time. It's getting there, but it's going to take a long time. So they will disagree, and they'll disagree with me all day. But when we get there, this motion will be very important to look back on, because it has everything that they did, and it's going to show everything they did that did violate Brady, and everything they did that hopefully the defense eventually gets these operating procedures, because they need that, especially for appeals down the road, and especially for the empirical data that needs to be done to rewrite systems and standard operating procedures in the future, because they're constantly changing those types of things so that they can run an operation or a lab or a hospital. even better, more efficiently. And, we're learning all the time about, things that work and things that don't work, and updating those and changing those and adopting new technology, which forces change. And so you have to adopt that new technology into the standard operating procedures, and that can influence an entire ripple effect of where the changes will go from that point on. It's kind of, what do you call it? It's flexible, ever moving, ever changing. Anyway, so that is what that paragraph reminded me of. This is going to be a very good motion to look back on when the laws do change. Thank you, Bill Thompson. Okay, where did I leave off? So, medical information. Similarly, the defense's own expert who previously oversaw a lab like Ortham and played a role like Ortham in law enforcement investigations testified such labs developed SNPs, profiles related to genealogy and ancestry rather than medical information, and developing SNPs related to the medical information in context of the IGG wouldn't be relevant nor probative nor appropriate. Furthermore, even if the defense's speculation were correct, it would not have changed the outcome of the court's decision. Moreover, even assuming there were sensitive genetic details revealed by the IGG performed here, the fact that the DNA was obtained from a crime scene and analyzed for purposes of identifying a perpetrator displaces any reasonable expectation of privacy. That is what's going to change right there. Because as we've learned, the how and the why and the mechanism of transfer, whether it was indirect or direct, experts are not educated or trained to testify to that. And so the scientific consensus is, at this time, we're unable to know when and how the DNA got there. So because this DNA was obtained at a crime scene, it may not identify the perpetrator, because we don't know the how and the when because of the nature of the trace transfer DNA. So yes, if Brian is not the perpetrator because his DNA was transferred to an object by natural means, because DNA is transferring all the time, 24/7, then yes, that would violate his rights. And that is another reason why they need that standard operating procedures, because of the nature of this trace transfer DNA. Because yes, it could be exculpatory, and yes, they could have looked at his medical things, and just because his DNA is identified at a crime scene does not make him a perpetrator. That's it. That is what's going to change in the future, because it's already coming. It is already in the Europe courts and in Australian courts. They are limiting the use of the trace transfer DNA. They are also limiting the use of that word more likely and the likelihood ratio because of this activity level. They are ahead of us. We are just being able to read that. And I was so proud that the scientists are now getting that into the scientific community and the scholarly journals, and Jacob Barlow is now getting it into our court system. That isn't what Bill Thompson is saying, or whoever wrote this is in direct opposition of what the scientific community is now recommending, that this is the nature of the trace transfer. So yeah, here it is. Let me read that again. Moreover, even assuming there were sensitive genetic details revealed by the IGG performed here, the fact that the DNA was obtained from the crime scene and analyzed for the purposes of identifying a perpetrator displaces any reasonable expectation of privacy. Not if he's not. That's not true if he's not the perpetrator. An identity from a crime scene does not equal perpetrator, not anymore. Moving on, the defense has not proven any of the elements necessary to show a Brady violation, and this court could deny the defense's motion. All right, let me come back and see what you guys are talking about. Hello, everybody. Mama's Thinking says, and he was excluded from any blood on the back of the sheet. Oh, I read that one. Mama's Thinking says, they assumed it was his and not the victim's. Yvonne says, I don't think that there was any of his DNA on that sheet. Maybe, after they swabbed his car door handle on the 29th of November. Yeah, very possible. Yeah, are we sure they swabbed the sheet? Because at first, didn't they say that the DNA was on the snap? Well, it wasn't on the snap part. It was on the other part. Gavon says, it could have already been in the house. I don't know that they found his skin cells only under the snap. It was not his DNA, or maybe no DNA at all. Right, we don't know. More circles, Momo's Thinking says. Absolutely. Momo's Thinking says, I gotta go. Thank you. Good night all. Aw, have a good night. Yvonne says the defense can't challenge the IgG because they have no way to do their own independent testing. I think that was on purpose. 100%. I think that's the whole reason. Yvonne Poole says, however, if they can't show proof that he ever owned a K-bar and sheath, they have no way to prove how or when his DNA got on the snap. Bingo. Yes. Yvonne says if they can't prove that he either ever bought or owned a K-bar knife, just clicking on them on Amazon means nothing. We are all suspects now, right? Absolutely. Hey, my spelling is atrocious. So I get it. I forgive you. I forgive you. I don't mind because I do it. So I don't want to, get on anybody else about it. Yvonne says, I like the water they say ISP inadvertently didn't include it in what they turned over to the state from Ortham BS. Yeah, I like the way they say ISP inadvertently didn't include it. Yep. Yvonne says they tried to say the blood on the handrail was irrelevant because it could have been there for a long time. More BS. Right. They got the argument backwards. It's supposed to be we don't know when the trace transfer DNA arrived on the object. It could have been there from a long time before. It's like everything the state is saying, it's actually the opposite. To Die For says, what does the Brady apply to or who? I was thinking that we should bring up what a Brady violation is. So we'll go over that. That's a great question. Yvonne says, I'm the only one running my mouth. Oh, we love it. Diane and I love it. All right. To Die For says they swabbed the snap. Wasn't his. They did? All right, let's get back to this. We are on page 15. We're almost done. C, the state does not object to the requested relief. The defense's factual allegations and legal arguments all fall flat, but perhaps the most perplexing portion of the defense's motion is the relief requested. And the ultimate concession of immateriality, the defense seeks only the exclusion at trial of the IgG information, even though the state has consistently said it does not plan to present the IgG information to the jury. This means that the state finds itself in the unusual position of strongly disagreeing with the rationale for the defense's motion, but having no objection to the defense's requested relief. As the state has explained as far back as the beginning of the litigation over the IGG, and as recently as its competing motion in Limine filed contemporaneously with the defense's motion, the state does not intend to introduce the IGG information at trial, other than the help the jury understand how the IGG investigation progressed. The state can do so by referring to the IgG information as a genetic tip without revealing the source or substance of the tip. An investigator can simply testify that law enforcement received a tip that, based on the information received, law enforcement took the next step in the investigation. Conclusion. The state did not act in bad faith, and the defense has failed to show the state violated its obligations under Brady. The court should deny the defense's motion to the extent that the defense requests sanctions against the state. The parties do seem to agree, however, that the IGG information should not be presented at trial. This court should thus enter an order excluding the IgG information at trial, other than as a genetic tip for the purposes of helping the jury understand how the investigation progressed. She got you, Bill. She got you. Is Bill the one who wrote this? Oh, Jeff Nye. Oh, she got you, Jeff. She got you. Because there will be laws and restrictions coming in the future, hopefully sooner rather than later. And they have it in this document. But they did it for the purposes to see if the identification of the person on the knife sheath was owned by that person. That's not how trace for DNA works. And Becca Barlow laid that out clearly in her motion. And she can press this further now that they have given more information to her to fuel whatever she's going to write next, or even argue in court. So, good job, defense team, for getting them to give you all that information. Diane says, there has not been a case where blood on a crime scene or DNA under the nails is not important. Uh-oh, did I just... Oh, no. I thought I just heard this beep. Uh-oh, am I live anymore? No, I'm live. All right, so we can look up the Brady. You know, wasn't somebody earlier saying that the defense set a trap? I think they did. All right, let me look up Brady. Brady violation. All right. All right, let me zoom in for this. A Brady violation occurs when the prosecution doesn't disclose evidence that could help the defendant's case. This evidence is known as exculpatory. So it's exculpatory. We'll have to double check that. And, well, it pulled it from these law websites, but we'll double check that. But the AI seems to think that just because it's not disclosed, that means it's exculpatory. So that Bill Nye was lying again. How does the Brady rule apply? The Brady rule requires prosecutors to disclose the relevant evidence that could help the defendant. The evidence can help exonerate the defendant, reduce their sentence, or damage the credibility of a witness. All right. Prosecution must disclose this evidence regardless of whether the defendant requests it. How can a defendant establish a Brady violation? The defendant must show that they couldn't get the evidence with reasonable diligence. Examples of Brady material include inconsistent witness descriptions. Well, we have that, I think, because the state originally said the DNA was found like on the snap, on the button, but then Riley Nolan said it wasn't. The button wasn't swabbed because they left it unswabbed for fingerprints. Pending charges against a police informant, evidence that the crime was committed by someone else, we have that too. The blood DNA profiles on the handrail and outside on the gloves, evidence that a witness for the government might be lying. What can the court do if Brady violation occurs? The court can declare a mistrial, which I don't think is going to happen here, but I guess that's definitely possible. The court can prohibit the prosecution from using unfavorable evidence. If both of the parties stipulate to a motion eliminate or to exclude the IGG, will the state still be able to use that's how they found them as a tip? I guess that depends on Hitler, where everybody is in agreement. They're not using IGG, and I wonder if the tip goes along with that. I hope it's all or nothing. It shouldn't be this, well, we're going to choose a little bit here and a little bit there to only talk about, and the rest of it we won't. So if Hitler is like, no, it's all or nothing, that tip could be thrown out. They might not be able to tell the jury that they found a tip. Yeah. And I do believe that it's coming, that a cold hit from a database, a defendant needs a little bit, needs to be able to defend themselves against that, especially in regard to trace transfer DNA when, okay, the DNA database can return a hit, but that doesn't mean anything. That doesn't mean that the how or the when the DNA arrived wherever it was found. So, all right. What did you think of that explanation, Diane, of the Brady violation? Yes. I do believe they are. Well, that's a good question. I think they've mentioned Brady violations in a few of their motions, but I can't remember off the top of my head specifically what they said. But you bring up a good point, because if they just like hinted at it, and then here we have the state just being like, oh, no, it wasn't Brady. No, you know? I wonder how that will go over. So that's a great question to see if the defense directly accused them of the Brady violation. I think they've mentioned it in cases, but I don't know if that was a mention or like an outright accusatory, this is a Brady violation type thing. Yeah. All right, so here's the next one. This one's short, so it'll only take a minute to read. To Die For says, I want to know if they filed anything. Well, for the Brady violations, is that what you mean? Just mentioning is a very short, right. So I think you bring up a good point. Maybe next time we see Heather Fitzgerald, we can ask her, because I can't remember off the top of my head. And then maybe I can look back through some of their motions and report back. But in the meantime, this one is from the state. It says it's the state's response to the defendant's motion for leave to file additional expert witness disclosures. Comes now the state of Idaho by and through the Latah County prosecuting attorney, and in response to the defendant's motion for leave to file additional expert disclosures dated March 3rd, 2025, advises court and counsel that the state does not oppose the court granting leave for additional expert witness disclosures. Particularly in this case, discovery has been complicated, dynamic, and constantly evolving as new information comes to light. The state believes it serves the interests of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. The state does, however, dispute the defendant's allegations regarding the state's lack of any real disclosure in part. Defendant's motion at page 2, as the court can see from the extensive disclosure by the state, this allegation by the defense is anything but accurate. All right. Oh, this was short too. We can read this one. It's the state's response to defendant's motion in limine number 10 regarding improper expert opinion testimony, Middleman. Comes now the state of Idaho by and through the Latah County prosecuting attorney in response to the defendant's motion in limine number 10. Improper expert opinion testimony, Middleman. Why do I keep calling him Middleton? It's Middleman. Filed on February 24, 2025 as follows. The state's disclosure regarding Dr. Middleman was in response and rebuttal to the defendant listing Leah Larkin and Daniel Hellwig as expert witnesses. In regard to the IgG matters and demonstrates his superior quantifications by education, research, and direct experience with investigative genetic genealogy, IgG. However, the defendant has indicated that he will no longer offer evidence related to IgG, including not calling Ms. Larkin or Mr. Hellwig. The state has no current intention of calling Mr. Middleman to testify in rebuttal. The state notes that it's February 24, 2025, state's mission in limine regarding investigative genetic genealogy, seeking, among other things, an order in limine describing to the extent which parties can refer at trial to investigate genetic genealogy used in this case is still pending. In light of the defendant's position that he will not be raising any issues related to IgG evidence, the state is willing to agree and now gives notice to the court and counsel that it will only seek to introduce evidence testimony that law enforcement received a tip without mentioning without mention of the source or substance of the tip, and that law enforcement then followed up and identified defendant. See state's motion in Limine number 11, exclude IGG evidence. All right. Okay, so here's the 404. Wait, I don't think we got this one. How long is this one? Oh, this one is short too. Is this the one we just read? Yeah. State's motion to defendant's motion for leave to file additional. Oh wait, we read that one. Okay, and this one they just wanted motion for permission to exceed page limit. Comes now, State of Idaho by and through the Latah County Prosecuting Attorney and respectfully moves the court pursuant to Rule 8 of 4th Judicial District Local Rules for leave to exceed page limit for state's response to defendant's motion in limine number 11, IGG evidence. The state's response presented to the court along with its motion exceeds the 15-page limit by 1 page due primarily to the citations and various portions of the transcripts. Okay. Diane says, I need to reread them all to connect the dots. Yeah, I think I need a refresher too because the state is very manipulative in the way that they cite things. So like they could completely take something out of context, and I don't want to take anything they say as fact because, we know how manipulative they can be. Yeah. So all right. Well, I guess, we read through all of it. And if there's anything else that happens, I'll pop on here again and we'll read it together. I think this was another fun live. So thank you, everybody in chat. Thank you, mods. Thank you, Diane, to IDAHO4. You're great. My mods are wonderful. Oh, Donnie Kane, welcome. Hello. It's so good to see you. We are just finishing up our live now. And I'll pop back on if there's anything else that happens or any more motions that are filed. So thank you, everybody, for coming, and have a good night. Bye.